Welcome to This Explainer. Today, we're going to unpack a truly fascinating real-world homeowner association dispute. If you've ever wondered exactly what happens when a passionate quest for financial transparency hits a massive legal brick wall, well, you're definitely in the right place. We are breaking down the case of Nancy Saxton versus the Lakes Community Association. We'll be looking at the official records and administrative rulings to really understand the exact legal mechanics at play here. We're talking procedures, timelines, and the incredibly precise wording of governing documents.
So, here's our quick roadmap for today's explainer. First, the fight for transparency. Then we'll hit the three major hurdles: the ticking clock, mandatory arbitration, and the legal definition of reasonably available. Finally, we'll wrap up with a final verdict. Let's get right into it.
Section 1. The fight for transparency. A homeowner's quest for financial clarity.
Okay, our inciting incident involves Nancy Saxton, a homeowner in the Lakes community over in Tempe, Arizona. Like a lot of folks, she became pretty concerned about her HOA's finances. Now, this dispute eventually escalated all the way up to the Office of Administrative Hearings in Phoenix, but it really started with a very simple, super relatable desire. A homeowner just wanted to find out exactly where her community's money was going. So, to get those answers, Ms. Saxton filed a formal demand to inspect the HOA's financial records in late 2012.
And wow, the HOA's response to her request was massive. Ms. Saxton received literally a large plastic tub containing roughly 3,700 pages. We're talking general ledgers, check registers, reserve studies, and American Express bills. The whole shebang. And as a quick little side note on the mechanics of pulling all this together, the HOA actually cut her a deal and charged a reduced rate for this massive pull, just 10 cents per page, rather than the 15 cents per page they're legally allowed to charge under Arizona statute.
But here's where things get tricky. There was a stark contrast in how the two sides actually viewed those 3,700 pages. For Ms. Saxton, the documents were so heavily redacted that they were basically useless. She felt it totally precluded her from evaluating the expenditures. On the flip side, the community manager for the Lakes testified that absolutely every financial transaction was included. They argued they only redacted protected private homeowner information and employee payroll data, strictly following state statutes. Plus, the HOA pointed out that unredacted versions were made totally available for her to review over at their attorney's office. Because the two sides just couldn't see eye to eye, the conflict escalated to an administrative judge. In this venue, the burden of proof fell entirely on Ms. Saxton. She had to prove her case by a preponderance of the evidence, which basically just means she had to prove that her claim against the HOA is more likely true than not. But, as we're about to see, proving the facts about the redactions was only one small piece of the puzzle.
Section 2. Hurdle 1. The ticking clock. The statute of limitations under Arizona law. So before the administrative judge could even rule on whether those redactions were fair or foul, Ms. Saxton faced her first major legal roadblock. Under Arizona state law, there is a very rigid one-year clock to file an action for a liability created by statute. And the absolute crucial thing to understand here is that this clock doesn't start when you finally get around to reading the documents. No. The clock starts ticking the exact moment a claim accrues, meaning the moment the legal violation theoretically happens. Let's look at the actual timeline because it's a real problem for the case. Ms. Saxton filed her initial demand for the records on November 5th, 2012. Now, by law, the HOA has 10 business days to fulfill that request. Therefore, any claim that the HOA failed their statutory duty would have legally accrued exactly 10 business days after November 5th. However, Ms. Saxton didn't actually file her petition for a hearing until right around November 25th, 2013. Yep, that is just past the one-year window. Her claim legally expired before she even walked into the room. Section 3. Hurdle 2. Mandatory arbitration. The power of HOA bylaws. But hey, let's play devil's advocate and pretend for a moment she had filed on time. The HOA presented a second, totally formidable roadblock, and it was buried right there in their governing documents. The community had an amendment to their bylaws that mandated any disputes must go to binding arbitration explicitly in lieu of filing suit in any court or filing any administrative action. The administrative judge pointed out that courts are legally required to construe arbitration clauses very liberally. So, because of this single bylaw, the administrative agency wasn't even the correct venue for her complaint in the first place. Section 4. Hurdle 3. Reasonably available. What constitutes fulfilling a records request? Okay, setting aside the strict timeline and the arbitration clause for a second, did the HOA actually break the law when they redacted those documents? Well, this hinges entirely on two little words in the state statute. Arizona law requires an HOA to make records reasonably available for examination by any member. But, and this is absolutely key, the statute is definitely not a blank check for homeowners. It explicitly allows an HOA to withhold records related to privileged attorney communications, pending litigation, and most importantly for this specific case, the personal, health, or financial records of individual members and individual employees.
So, looking at the HOA's actual compliance steps, the judge found they really did make a significant effort. I mean, they handed over a massive volume of financial history, and when those redactions were challenged, the HOA went an extra step. Their legal counsel took the raw, unredacted documents, applied the specific statutory redactions themselves, and then officially invited Ms. Saxton to come down to the attorney's office. They gave her the chance to review the unredacted originals just to verify the information.
And that brings us to the ultimate impasse. Ms. Saxton actually testified that she was not keen on going to the attorney's office. She felt intimidated by it, she believed she'd just be looking at the exact same documents she already had, and she ultimately decided the whole visit would just be futile. But because she declined this official offer to view the unredacted documents, the judge had to evaluate if the HOA had already met its legal duty to be transparent. Section 5. The final verdict. The administrative law judge's decision. So after weighing all the testimony, the strict timelines, and the bylaws, Administrative Law Judge M. Douglas issued a very clear, comprehensive dismissal. The judge ruled against the petitioner on all three fronts. Strike one, the clock had run out, the petition was filed past the one-year statute of limitations. Strike two, even if she was on time, she was in the wrong venue because the bylaws demanded binding arbitration. And strike three, even ignoring those first two procedural hurdles, on the actual merits of the case, the HOA followed the law. By providing 3,700 pages and offering that in-person review at their attorney's office, they successfully made the records reasonably available. All avenues for the complaint were officially closed. Shortly after the judge's ruling, the decision was officially certified as final by the Director of the Department of Fire, Building, and Life Safety in July 2014. This completely solidified the Lakes Community Association as the prevailing party, officially putting an end to the dispute.
As we wrap up this explainer, this case leaves us with an incredibly powerful takeaway. A homeowner's genuine, honest desire for transparency is completely powerless if it isn't matched with a strict adherence to legal procedures and timelines. Missing a deadline by just a few weeks or misunderstanding a single paragraph in an annual bylaw amendment can entirely dismantle your case before it even begins. So it leaves us with this question. How well do you actually know the hidden rules, binding timelines, and dispute clauses buried inside your own community's agreement? Think about it. Until next time, keep reading the fine print.